introduction, and I'm also happy to see all of you coming here this talk at this hour. So as Emily just said, and as the title suggests, I will discuss military courts in Israel and in the occupied Palestinian territory, and the way they reflect and reinforce ethno-national boundaries between Palestinians and Jews, implicating political membership and citizenship. Well, at present, and this is how most people hear about military courts with relation to Israel and Palestine, military courts in the West Bank are one of the main mechanisms that are at work in sustaining the occupation, creating mass incarceration of Palestinian society. Palestinian prisoners are held in prisons inside Israel and become part of the Israeli criminal justice system. The military courts currently are responsible for about 1/3 of the entire prisoner population in Israel. The military courts in the West Bank process thousands of cases of Palestinians every month. They try criminal cases with charges, evidence, plea bargains, and sentences. You might have heard, for example, about Ahed Tamimi in the past year. She's been charged in such a court. They also process cases of administrative detention, where people are detained without charge. If you have heard, for example, of Khalid al-Jarrah, a member of the Palestinian Legislative Council, she's been held in such a detention for many months, and it's been extended. So it's very much alive today, this mechanism. Many of these cases are connected to resistance to the occupation. Some of them, though, involve horrific and deadly attacks on innocent civilians, and we should not forget that too. As an Israeli lawyer, like you've been already told, I defended Palestinians from the occupied territories in military courts. I also litigated security-related cases in Israeli courts, where my clients were typically Palestinian citizens of Israel. I litigated other cases regarding the occupation, like cases of the separation wall or family unification between Palestinians from Israel and the occupied territories. So my involvement with the occupation brought me to study international law, which is considered the legal framework that is relevant for this type of regime. However, I found it a very limited framework that, for analysis, it could not explain what I was seeing and experiencing, and does not provide explanations that I was looking for. So my research departs from international law and looks into the legal history beyond 1967. And the occupation into the more, into the legal history, into the sociological aspects of the law, the legal practice, and the legal institutions that are at work. For this research, I used military courts cases that I have reviewed in the archives of the Israeli military, other kinds of archival documents, and interviews that I conducted with legal actors, former judges and prosecutors, both in military courts and in the civilian Israeli justice system. This is very much a work in progress. It hasn't been published yet. It's the dissertation that I'm about to submit, so I would be very happy to hear your comments. And if you have, during the time that I talk, we'll have a Q&A in the end, but if you have any clarification questions, because these things can get complicated, so if you think that you don't understand something and want to clarify something, you're welcome to jump in and ask, so everything will be hopefully clear. So within the more mainstream study of the Israeli legal system, military courts of the occupation are being discussed as a singular and an exceptional phenomenon. This view is related to the wider perception of the occupation itself as an exceptional situation, as an external outpost of the internal Israeli democracy. The conventional framework thus portrays Israel within the 1948 borders as a democratic state with a civilian, independent judiciary, and the occupied territories as external, held under temporary military government, and military courts just form part of this total entire military regime and are legal according to international law. So the point of departure of legal discussions of the military courts are the Geneva Conventions of 1948 that discuss occupied territories and as you can read here, they allow the occupying power to replace some of the legislation of occupied territory and then establish military courts, properly constituted non-political military courts that can prosecute violations of these laws of the occupier. And so the framework is that military courts were established following the occupation. But while the concept of the occupation as an exception to the Israeli regime has been challenged and portrayed as part of a larger colonial project of Zionism, this paradigm shift has not yet been applied to the legal system that Israel operates in the occupied territories, which is where my research comes into play. So the framework of my analysis is not confined either to the occupied territories or to Israel within the 48 borders. I regard Israel and the occupied territories as a single analytical unit, like what Anne Laura Stoller called an imperial formation. So it's a political unit that is larger and more fluid than a single nation state, consisting of different forms and different degrees of sovereignty and rights. So, as I'm about to tell you today, the military courts in the occupied territories are far from being an exception to the Israeli legal system. They are actually closer to forming the rule for that system. So, if you see here the photo of Tamiya, which many of us have been exposed to in the last year, this is a photo from her trial in a military court in the West Bank, and you can see her in the middle, her lawyer, which is a friend and a colleague, and the military guards. I was very happy to find such similar photos. The right one is from a military court in Lod, which is a city in Israel in 1969, and again we have the young woman defendant in the middle and her lawyer to the left, and probably, I don't know if it's her father or someone else, and the military guards around her. So, military courts were operating inside Israel and before the occupation, which I'm going to get to in a short while, in very similar manners to what is happening nowadays in the West Bank. Actually, there has not been a single day since Israel was established that it has not subjected Palestinians to military control and prosecuted them in military courts. This unstated rule, until the year of 2000, was that Palestinians are being prosecuted for security-related offenses in military courts, both inside Israel and in the occupied territories. This rule has started to decline in 2000 when that court was abolished. So I think in the long run, we're witnessing a decline of this phenomenon that is accompanied by a price that the Israeli civilian justice system is paying, because it is being gradually, to a lesser extent, but it is being militarized to an extent. This continuity of military courts bring me to see them not as a deviation, but as a structure. The current legal critique of military courts is focused mainly on due process rights, or rights of the defendants. Military courts have been described in legal literature as reflecting due process exceptionalism. I suggest to conceptualize the critique differently, as what other scholars, starting with a German scholar called called enemy chronology. According to this theory, there are certain parts in the criminal law of many states, including liberal democracies, that treat the accused as an enemy rather than as a member of society. The legal treatment of an enemy includes violations of due process, but also other types of characteristics. Broader criminalization, so more acts are being criminalized that normally would not have been criminalized, and harsher punishments are being inflicted. It is a form of criminal law that is excluding, coercive, and punitive. It does not consider the possibility of rehabilitation and reintegration into society. I thus consider military courts as a kind of an institutional articulation of enemy penology in a rather extreme and vivid form, right? Because the military is the state organization that is meant to confront enemies. And the institutional separation from other kinds of courts and legal proceedings facilitate differentiated and harsh legal treatment. So what I want to focus my talk about today is the multiplicity of military courts that actually, and the variety of military courts that Israel has actually been applying between 1967 and 2000. And I focus on what a legal historian named Lauren Benton called jurisdictional politics. So, as a legal historian of the colonial world, Benton teaches us that jurisdictional lines, which separate legal authorities, were the focus of struggle in the colonial world, precisely because they signify other boundaries, marking religious and cultural differences. Jurisdictional lines in such politically complex settings are not territorial, but they involve classification of people to different population groups, an important facet of colonial legality. While Benton is discussing tribal laws and religious laws and laws that originate in different legal authorities, I am trying to apply this concept into a different structure of later colonial law, the structure of emergency laws. So in the late British Empire, the British have made, and I'll get back to that in a short while, the legislation of emergency laws was a very important facet of British colonial legality. So I argue that the dual structure that emergency laws create with the ordinary criminal law, although they both originate in the state, they create this space for jurisdictional politics, for this interplay between different legal authorities. And the jurisdictional politics of civilian and military courts in Israel and Palestine designated Jews to civilian jurisdiction and Palestinians to military jurisdiction. So I try to show here how these jurisdictional principles were created and transformed from territorial principles that were set by the law to racialized principles differentiating ethno-national populations. The making of these jurisdictions in the Israeli context was not only a replication of colonial structures. These jurisdictional divisions were practiced within a state that at least self-proclaimed itself as committed to democracy, to the rule of law, and to equal rights under the law. So even if only formally, as a consequence, different types of classifications were used to align with these self-proclaimed principles. So these classifications both create and disguise ethno-national divisions. So I'm going to, I'm sure most of you are familiar with it, but it's helpful to have the historical outline in front of us when we discuss this. So actually the first ones to introduce military prosecutions of civilians in mandatory Palestine was the British government of Palestine, which enacted the Defense Emergency Regulations starting in 1937. The British enacted that, like in other parts of the British Empire, to counter insurgency. They used them first against Palestinians in around 1936 and on with what was called the Arab Revolt, but later in the 1940s also against underground Jewish movement that were resisting the British rule over Palestine. So in addition to many other powers like censorship and deportation, the regulations included a section of security-related offenses and authorized military courts, and this is how they came into the picture. These regulations were not dependent on a declaration of emergency or of what was known as martial law in the past. They did not suspend ordinary criminal law, but were applicable at the same time, concurrently, creating this dual structure that I was talking about of criminal and emergency law in a parallel criminal universe. So after Israel was established in 1948, it actually kept these emergency regulations in force and used them. The Palestinians that remained in Israel following the Nakba were granted Israeli citizenship when the state was established, but at the same time they were subjected to a military regime between 1948 and 1966. The military regime was enforced on geographical areas that were densely populated with Palestinians, and they enforced a kind of a movement regime. People had to get permits in order to move from one area to another, or from the village to the city. And one of the main purposes was to take over land and not to allow Palestinians to return to their land and the like. And during the military regime, this photo, I took it from a book by historian Shira Robinson, Citizen Strangers, that is about this time of the military regime. So the military regime was enforced through military courts, and you can see here this kind of military courts in 1957. So not only inside Israel, but also long before the occupation, obviously. So this military regime was formally abolished in December of 1966 after it was found to be useless in terms of security and has achieved its goals in terms of taking over Palestinian land. The military courts of the military regime in 1966 were not entirely closed down, but they were falling out of use. They were hardly used. And then came the 1967 occupation that you have a map here for whoever needs it. So Israel occupied the Golan Heights, the West Bank, the Gaza Strip that you see here, and also the Sinai Peninsula. Following the occupation of 1967, Israel created another system of military courts, okay, in addition to the one that was active during the military regime. Israel enacted a set of military orders in the occupied territories, a criminal law actually for the occupied territories, which was named the Security Provision Order. It was based on the model of the British emergency regulations that I was talking about before. It was different in the sense that it was enacted by the military and rephrased, but it was the same model. And it also established military court. So that was in the occupied territories in 1967. But that was in June. Quite shortly after, in October of 1967, another military court was established inside Israel, based on the same British emergency regulations that were still in force that we talked about before. So this court in the city or town named Lod was meant to counter violent resistance to the occupation that was taking place not in the West Bank or in the Gaza Strip, but inside Israel, either in occupied and annexed East Jerusalem or in other parts of the country. The court was established ad hoc for a certain trial, for a certain case, but it actually continued to operate for over 30 years. And that first case was an attack or an attempted attack in East Jerusalem. And all the first cases of this court originated from East Jerusalem. And to a large extent, this is why I see it as kind of a result of the annexation of East Jerusalem, where Israel incorporated a large group, some 70,000 Palestinians that were just like other Palestinians in the West Bank. But since East Jerusalem was annexed, it was impossible legally to prosecute them in the military courts of the West Bank, so they needed some other mechanism to do that inside Israel. But very, very soon, this court was used to also prosecute citizens of Israel from all parts, not only residents of East Jerusalem, and it continued to do so for over 30 years. So this is what I mean when I say that the occupation had a boomerang effect on Palestinian citizens of Israel, creating another form of military governance over Palestinians in Israel, reinstated form of military control that was thought to be declining after the military regime, and reframing Palestinian citizens as enemies. So the period between 1967 and 2000, while this court was operating, was a period of multiplicity, 2 systems of military courts, and the civilian justice system, which was also operating. So we have 3 different systems that can be, cases could be brought to and could be navigated one against the others. Or, yeah. So, and all these systems prosecuted national security cases. So what is the consequence of this multiplicity of systems? I will tell you 2 short stories that might make this more specific or understandable. So I take 2 cases. One of them is Barak Nir, who was a Jewish Israeli citizen. He was part of a group that was called Jewish Underground that was exposed in the 1980s. This group of Jewish Muslim settlers, but not all of them, planned and attacked Palestinians, exploded cars of mayors in the West Bank, and killed other Palestinians. So Barak Nir was a member of that group. He participated in a killing in the Islamic College in Hebron. He drove the people that went there and killed 3 Palestinian students in that college. And he was arrested and prosecuted in a civilian court, a district court in Jerusalem, for his involvement of what I just described. He was charged with manslaughter, and the maximum punishment for what he did was 20 years. He was sentenced to 6 years imprisonment, and then he was pardoned by the Israeli president to 2 years, and then he was released after these 2 years. So that is not part of the course, but I can't tell the story without continuing it till its end. On the other hand, I take the case of Mansour Ziada, who was a Palestinian citizen of Israel, who was convicted in 1988, only 4 years later, in this court, in the military court in Jordan. He was convicted of membership in the Popular Front for the Liberation of Palestine. He threw, with others, a hand grenade onto a civilian bus. Luckily, the grenade did not explode, and nobody was hurt, but he was still prosecuted for the membership of the organization and for all that he did, for possessing arms and throwing the grenade. And according to the defense regulations, his maximum punishment was death. And he was sentenced for life imprisonment, which was indeterminate, so he could be in prison for his entire life. He was released in 2011 after serving 23 years in prison. His release was part of a prisoners exchange with Hamas when Gilad Shalit, the Israeli soldier, was returned. So if it hasn't been for this exchange, he might have still been in prison like many others who were prosecuted in this court. And according to the terms of this deal of his pardon, if he's ever convicted again, his life imprisonment can be reinstated. So you see the differences in the cost of life, actually, that was articulated through these different systems and these different punishments. It's not only a story of double standards or racial bias or discriminatory levels of punishment. It's really an entirely different system, entirely different legal framework that controlled the 2 cases, from the law that they were prosecuted under, the definition of offenses, the courts, the punishments, everything was different about that. So it's different from other narratives that we know about racial bias or racial profiling, in the sense that it's not within the same system, but actually they're channeled to really different systems. So what I now want to kind of shortly get into is how did the jurisdictions of these courts, how were they constructed in a way that Jews would go that way and Palestinians would go that way, because that was not part of the law. None of the laws involved stated, we are a court of Palestinians and we are a court of Jews. So I'm going to tell how did that happen inside Israel and in the occupied territories, because it was a little different. So inside the occupied territories, the system of military courts was originally designed for the occupied population, for Palestinians. But then it did not, these preparations did not foresee the presence of Jews within these territories. So very soon after the occupation, Jews came into these territories as tourists, as consumers, and soon after also as settlers. And when they committed offenses in these territories, they were outside the jurisdiction of Israeli courts. And so the military and the government didn't know exactly what to do about it. They weren't prepared for that. So they issued a kind of emergency regulations that have been extended ever since and are still in power today, but with changes. And these emergency regulations actually extended the jurisdiction of Israeli courts into the occupied territories. So someone who committed an offense in the territories would have been able, like Israeli courts could prosecute them, the police could take them and bring them to the justice in Israel, which otherwise wouldn't be possible. So I don't want to get too much into the legal technique of doing this, but as the settlement project continued, the population of the territories became more blended, and it presented problems as to who would be prosecuted where. The original version of these regulations I was talking about used the term any person. So any person who committed an offense in the territories can be prosecuted in Israel. But then this related to any person. So in principle, Palestinians could also be prosecuted in Israeli courts, and that was not the intention. So you can see the amendments of these regulations over time as reflecting what had happened and the aims of the government in relation to the jurisdiction of the military courts. So the definition of person was then changed, and then just one second, were amended to exclude Palestinians from the jurisdiction of Israeli courts. And in order to do that, they used a different classification, and the classification was a resident of the region. So whoever was a resident of the region was not under the jurisdiction of Israeli courts. But settlers, after a few years, also became residents of the region, right? This term, residents of the region, could have been interpreted as including settlers, and this had to be amended again, and then this classification was again changed, and the next classification was whoever is registered in the Israeli, I missed that word here, in the Israeli population registry. So specifically to persons who are registered in the Israeli population registry, they were under Israeli courts, and who was not registered was under the jurisdiction of military courts. So you see how the very general person then is becoming more and more specific to a territorial definition of a resident of the region, and then to a personal definition actually of who is registered in the population registry. But to start with, actually, even residents of the region who were Jewish were kept under the jurisdiction of military courts for specific offenses that were regarded as security offenses. So when they violated orders of the military commander, they were, in fact, in the beginning, prosecuted in military courts. But that did not last very long. In 1976, the military prosecuted a very prominent settler figure named Rabbi Levinger in a military court. He was from the Kiryat Arba settlement in Hebron. Levinger resisted his prosecution in military court and attracted huge media attention to his trial. And his lawyer argued that he shouldn't be prosecuted in a military court, but in a civilian court in Israel, since he was registered in the Israeli population registry, like we have seen. And you see here a part of the lawyer's argument, right? This is a case, in fact, against the entire Kiryat Arba population, the lawyer argues, and not against a single person. The big question is, are the residents of Kiryat Arba considered stepchildren of the state of Israel, of the land of Israel? Are we holding Judea and Samaria, which is the biblical terms for the West Bank, under lease, and are the settler residents only subleasing? The defendant wishes to draw the attention of the court to the fact that his rights are compromised in relation to the rights of all Israeli citizens, because he's in a military court. So he has no right of appeal, no proper procedures, the levels of punishment are higher, exactly what I can describe as enemy penology, the lawyer is arguing here. And the legislator was aware of that, and this is why he authorized the civilian courts of the state of Israel to actually prosecute people who are registered in the population registry. So they brought all the argument, and it was in the press, and the court actually rejected this argument. But then the prosecution authorities did not want to mess with it anymore, did not want to prosecute settlers anymore, and soon after this case, there was a policy decision to transfer all the cases of Israeli citizens, including settlers, to the civilian courts in Israel. So you see here the combination of the ideological argument about Jewish entitlement to the territories, but also arguments about rights of citizenship and equal treatment and due process rights. This change in prosecution policies after this case brought about a complete separation and division of populations along ethno-national lines and the abandonment of any territorial principles. Israeli settlers were only in civilian courts, and Palestinians were prosecuted only in military courts in the occupied territories. The process in Israel was similar, but yet different in other senses. So distinctions based on citizenship and registration were not available inside Israel, because both Palestinians and Israelis were all citizens and were all registered and were all residents of the same state. Nevertheless, the same distinction was made. So theoretically, the military court in law that I was talking about had jurisdiction over any person in Israel, including Jews, of course. And the decision on where to prosecute had to be taken by the Attorney General, and this is the administrative guideline that they have that actually, if you look at it, doesn't include any substantive criteria. So there's no, these classifications we saw are not here because they are not available. It's just as if the prosecution authorities have complete discretion around which case to prosecute where. If you look here, each case could have been prosecuted anywhere, but if you look, as I did, at the annual reports of the military prosecution, describing what had actually happened in the court, defendants are referred to according to their domicile, which reveals their identity as Palestinians. So when these cases are being described, they use these categories, these classifications that are more bureaucratic. Resident of Hebron or Gaza or Arab Israelis, etc. So I reviewed hundreds of decisions of this court, finding no single case of a Jewish Israeli defendant, and security cases of Jewish defendants, like the one I was talking about, of Barak Nir, were actually being prosecuted in civilian courts. And the interviews that I conducted brought me to the conclusion that the body that actually made the decision about which case to take where was the Israeli Security Service. They had decided which cases they're interested in and then transferred them to the military prosecution. And this conclusion of deciding along ethno-national line is confirmed by a statement of the legal advisor of the Security Service behind closed doors in an internal discussion in the Ministry of Justice, the legal advisor of the Secret Service stated that their policy is not to prosecute Jews in military courts, and actually only terrorism offenses by Arabs in Israel are prosecuted in military courts. So we see the same things, but with different techniques of doing that. So I now want to move on to the later developments, which finally brought the abolition or the closing down of the law military court and change of this policy that I was talking about. Over time, the fact that the law court was used to prosecute Israeli citizens became a source for tension because of these democratic values that were proclaimed. And if we look at the law military courts, we can see two frameworks through which the Israeli citizenship of the defendants were understood. In many judgments of that court, the court presented a harsh approach against Palestinian citizens that portrayed them as disloyal and as failed citizens. However, in internal discussions and deliberation in the Ministry of Justice, the different treatment of Palestinian citizens became to be seen as a problem. In the court judgment, the citizenship was actually understood as a duty more than as a right. Security offenses were perceived as a breach of loyalty to the state, and they actually were used to justify harsher punishments, harsher than Palestinians in the occupied territories who weren't citizens. Okay, so Israeli citizens were actually treated harsher. And it served also as an opportunity to pass judgment on the individual defendant, but also on the entire Palestinian minority. So I take as an example a case from 1972 where a young citizen of Israel, Yusuf Mansour, 20 years old, was sentenced to death by the military court. He was part of a group that planted a bomb in a civilian bus. The bomb exploded and caused injuries of passengers. Other defendants were from the occupied territories, and they were sentenced separately. He was sentenced, they were sentenced to life, and he was sentenced to death, to life imprisonment, I think. And this is what this is how the court justified the death sentence. So the defendant was born in the state of Israel, and he's a citizen who owes it the duty of allegiance, not only formally, but due to everything the state has given him, the inhabitants of his village, and Israeli Arabs more generally. Instead of expressing his gratitude to the state of Israel, the defendant has joined those seeking its destruction. So the court expects him to be grateful and uses citizenship as an aggravating circumstance, which justifies the most severe sentence. The case went on appeal, and the death sentence was revoked. The military prosecution had a policy throughout the years not to impose death penalties. But actually, the reliance on citizenship as an aggravating factor was only strengthened. So the military court of appeal rejected the argument that he should also be like his fellows from the occupied territories, and insisted that his citizenship made his case more serious, saying that the appellant, as a citizen of Israel who eats its fruit, drinks its water, and enjoys the state's shelter and protection, is obliged to a level of loyalty that is not expected from foreigners. The bond of citizenship may, especially in offenses against the state, determine if a certain act is also an act of betrayal of the state, and can certainly be a discriminatory consideration with regard to the punishment. So they did justify the principle, although they have mitigated the sentence. So the same ethno-national logic that I was talking about that determined the justification is also at work here with regard to the punishment. Well, the demand of complete allegiance to the state, of course, ignores two fundamental contradictions about the citizenship of 1948 Palestinians. First of all, it ignores the fact that when the state of Israel defined itself as a Jewish state, it never committed to the interest of the Palestinian minority within it, but still expected them to commit to the state in an unequivocal manner. And second, it ignores the conflicting loyalties that Palestinians were placed within when they were granted Israeli citizenship to their people and to their state. And the unambiguous demand for exclusive loyalty to the state, in fact, is a demand to abandon at least some of their loyalty to the Palestinian collective. So this is one framework of how Israeli citizenship was understood in this court. But as I said before, there was another framework that was enforced within the Ministry of Justice and in internal discussions. And that other framework presented a liberal civic understanding of citizenship based on the idea of the rule of law and equal rights. And it was brought up in internal discussions during the 1980s, but no one really did something about this court that became to be kind of a burden and troubling. And I can't go in this talk into the entire analysis of why this court was actually closed down, but I will put just to touch on one aspect of it. So sometime between 1996 and 1999, the end of the 1990s, the Chief Justice of the Military Court of Appeals, his name is Ilan Shif, suggested to close down the military court in Lod and transfer all the cases to the civilian justice system. The 1990s were a period where liberal values in Israel were rising, a time of when the Supreme Court, basic laws about constitutional rights were legislated, and it was called the Constitutional Revolution in Israel. It was also after the Oslo Accords and before the Second Intifada, so it was the time when Palestinian citizens, the status of Palestinian citizens in Israel improved significantly. So the suggestion by Shif to close down the court met with approval with the military chief of staff, the Chief Justice of the Supreme Court, and the General Attorney in Israel. They took this decision, however, without consulting the Secret Service. So they just left him out of the... There were not so many discussions. It's weird how it passed very, very easily, and the Secret Service were actually not part of the process, which can somehow explain how this passed. So I interviewed Ilan Shif about this move of his to abolish this court, and he, when he explained his position, he refers to the differential treatment of Palestinian citizens, and he says, when there is a military court, normally it is Arabs and Palestinians who are brought there. Jews in most cases don't get involved in these offenses, so it creates a sense of discrimination. A Jew who commits a terrorist attack would not have ended up in a military court, although both kinds of court do justice. So as a military lawyer, he doesn't think that this court doesn't do justice, but he is troubled by the sense of discrimination. But there was another sense in which the citizenship of Israelis became troubling. It was also because it was seen as a question related generally to Israeli citizenship and not only to Palestinians. As I mentioned earlier, when the settlers struggled against their prosecution in military courts, they framed their argument in terms of their Israeli citizenship. So the decision that I was talking about in the 1970s to try settlers in civilian courts was understood, at least by some people, as connected to their status as citizens and the equal right that they deserve, just like other Israeli citizens. And the issue of prosecution of settlers, although it was decided in the 1970s, it remained contested over the years because there were figures in the Israeli Ministry of Justice that sought to reverse it and wanted to prosecute settlers in military courts again, especially when they turned against the Israeli military. And this repeated contestation forced military lawyers, military prosecution that did not want to deal with the settlers, it forced them to repeatedly present their position against that, against trying Israeli civilians in military courts. And Ilan Schiff was one of these lawyers that they constantly had to say, no, citizens should not be prosecuted in military courts. This is one of the arguments they presented. And that argument that they constantly had to make created a difference between the interpretation of citizenship of Jews and of Palestinians. So Jewish citizenship was seen as including the right to a civilian trial, while Palestinian citizenship was not viewed this way, since Palestinian citizens were still prosecuted in military courts. But when finally he, Ilan Schiff and the system around him came to this position that the court should be closed, in explaining that, he refers directly to the issue of settlers. So he's saying, regarding military courts, the law of military courts, I saw no reason for continuing to operate it. I had a principle that citizens should be prosecuted in a civilian court. The exception in the occupied territories is according to international law. And mentioning citizens, I was also against the prosecution of settlers in military courts. So I just want to make a small remark. In Israel, the word citizens and civilians, it's the same word. There isn't that distinction, so it's hard to know exactly what he's referring to when he said. But anyhow, they are one of the same in this context. So he's saying, well, I formed a principle according to which settlers should not be prosecuted in military courts, and I apply the same principle later to Palestinian citizens of Israel. So that principle, that citizens should not be prosecuted in military courts, was forged in the context of the status of settlers in the occupied territories, and first came to be understood as such with regard to the settlers, but and that understanding was solidified during those years of discussions. And then it was applied to the rights of Palestinian citizens. And finally, the court was closed down in 2000. Although that court was closed down, security cases are now being prosecuted in civilian courts. Some of these cases still bear strong resemblance to military proceedings. I don't think that it is the same, and I'm not saying that. It is not the same, but the Israeli criminal system has been going through a process of militarization, and the concept of enemy penology is not exclusive to military court. It can certainly still be alive in the civilian courts and until today. So in starting to conclude, I want to make a few more general points. So Patrick Wolf famously argued that settler colonialism is not an event but a structure. And I want to paraphrase on that and say that military courts are not a response to an event, are not a response to the occupation, but they are rather part of a structure. The colonial structure underlying the Israeli state explains the operation of military courts throughout Israeli history. And the military courts cannot be explained by the provisions of the Geneva Conventions or by the occupation. Personal and status-based jurisdictions were typical to pre-Enlightenment and colonial legal systems, but they became illegitimate under a state legal system upholding the idea of the rule of law. This transformation of jurisdictions that I have pointed to, from territories to personal status, represents a reverse process from the systems of the rule of law to actually a kind of a colonial system. From jurisdictions that are based on principles associated with sovereignty, territorial sovereignty, to principles based on ethno-national principles and colonial governance. This pattern of differentiated jurisdictions reinforced ethno-national social boundaries and constructed one population as needing and deserving protection, and the other population as a dangerous enemy population presenting a constant threat. The citizenship discourse in Israel, though, and this is another conclusion that I want to draw, cannot be isolated from the occupied territories, as I have hoped to have shown you. There was a constant reflection back from the occupied territories onto the Israeli metropole. First, the occupation reframed Palestinian citizens as enemies, and then the concept of citizenship that was forged around the status of settlers reflected on the citizenship of Israeli Palestinians. More generally about military courts beyond the Israeli context. So there are several criticisms to military courts, and I think this story strengthens them. The first one would be that a military justice system is a totalitarian form of criminal justice where there is no separation of powers, no checks and balances, there is no independent judiciary, no representative legislator. The military makes the laws, brings charges, and judges the defendants. This I believe to be the most important criticism, and we should not forget it. So Palestinians in military courts do not take part in creating the laws that they are being prosecuted according to. The second criticism is more internal to the law and to the legal process. It should not be concentrated as it is on due process of law, but about what I have suggested at framing it as enemy chronology, a repressive form of justice that reflects the treatment of an enemy, so criminalizing more acts, punishing more severely, and violating due process rights. The third criticism that I raise is that this type of legal system, in fact, in practice, targets and marks social groups as enemies. It is not administered individually and is not administered equally. Typically, military courts are applied to target groups, suspect communities, dangerous populations that are often being constructed in a racialized manner as dangerous and threatening and undeserving a legal process which respects their individuality and their humanity. What we can also learn in a more maybe positive or hopefully inspiring way from this historical development is that military courts, like any social institution, are not static. They can be challenged and they respond to criticism, and this is why I think it remains extremely important to criticize them. Thank you.